And thank you very much for keeping your dials here on Joy 99.7 FM on radio. We are listening to us also on over a dozen affiliate stations across the country, and also on Love 99.5 FM in Kumasi. And you're watching us on your multi-TV's Joy News channel. Thanks for making a date with us on Newsfile. This program is brought to you by MTN Everywhere You Go and Star Assurance, your solid partner. My guests are taking their seats in the studio, and we're just going to the discussion right away. Starting from my very extreme right is Abdul Malik Kwekubaku Jr. He's a managing news editor of the New Crusading Guide newspaper. He is a regular panelist. Good morning, Abdul Malik, and welcome to the show.
Okay, my brother.
Good. And then Abraham Amalba. It's been a while.
Yes.
Haven't had you on Newsfile.
That's so.
Okay. Great to have you also here. Abraham Amalba is a legal practitioner. He is with the NDC's team that is currently battling the petition at the Supreme Court. N.S. Thompson is a legal practitioner. He's also joining us this morning. Thank you very much for joining us.
Thank you.
Good to have you. We had been expecting the Honorable Mahama Yaraga, but good to have the guys here. Gabi Asario Chiridako of the NPP. He is with the Dankwa Institute. The executive director of the Dankwa Institute will join us shortly. Thanks very much. Your text messages are welcome, 1422. And you can also post your comments on our Facebook wall or send me email at newsfile@myjoyonline.com. Abraham, you were in court this week, so it's good to start with you. The court has eventually now been able to, narrow down, like we say, the memorandum of issues to 2. And you have now been given the 16th of April to come and start the matter in earnest. How does it feel that now you're sure that the case is starting?
Let me start by saying good morning to your listeners and viewers, wherever they may be. At the last adjourned date, the Supreme Court fixed 16th of April as the day set aside to start the hearing. It has come, and both parties, the respondents and the petitioners, are happy with the date. But there were a number of things that took place on that day. On that day, the Supreme Court, but before then you realize that there was an order by the Supreme Court for the parties to go back and sit down and try to fashion out a common memorandum of issues. This the parties failed to do. And so the Supreme Court took it upon itself to then narrow down the issues as you rightly indicated. So the first issue was whether or not there were irregularities, malpractices, violations that affected the conduct of the 2012 election, that's the presidential election. The other one is whether these irregularities have affected the outcome of the results. Now, on our side, we think that this actually summarizes the issue that is confronting us in court. We think that the two issues aptly describe the issues that we are all confronted with. And so we were happy with the issues. But the mode of trial is what also came up for discussion. Initially, the Supreme Court wanted evidence to be taken by way of affidavit. On our side, we were uncomfortable. And so the Supreme Court had to take a break, and I'm sure they consulted, and they came out with two modes of trial. The first is that the respondents and the petitioner, that's the parties to the suit, would give viva voce, that is oral evidence, while witnesses would have to come by way of an affidavit. And so the two modes of trial.
So we are expecting to have Nana Addo Dankwa Akufo-Addo, Dr. Mahmoud Bawumia, and Jacob Echebe Lamte
take the witness box.
Get in there, give their evidence in chief, get cross-examined and re-examined if possible, and then we're going to expect the same of the respondents. Is that the case?
That is so.
So the president will be in the box. Is that what is going to happen?
We, as a team, are devising a strategy. We do not think we would want the president to take the witness box. And that strategy would not be divulged here.
I see.
It is close to our chest.
What other options are available to you if the president will not be in the witness box? He will swear to an affidavit, is it?
He could
Which
do
he
that.
Has already, he's already
yes,
done.
Yes, he could do that. He could also allow one of the respondents, in this case NDC, to give evidence on his behalf.
That is so.
So it's possible any of these scenarios could happen. And so we haven't looked at the two modes of trial, are comfortable of it. But there was one issue that the petitioners' lawyers raised, and they were not allowed to have their day. They wanted a PowerPoint presentation of their evidence. And the Supreme Court felt that they were challenged. They felt that they didn't have the capacity to follow on such type of presentation. Particularly, some were of the view that because they lacked the knowledge or they were not technologically savvy, they were not capable of following if it is on a PowerPoint presentation. And one will have to agree with them because these are people in their 60s, and by then there wasn't any computer.
Is it the case that they will not be able to follow, or that the technology is not available with the Supreme Court?
The first was what I said. The second one was the technology, the absence of the technology within the Supreme Court, and that you could find that they were writing in longhand, even though they spoke through a mic and it was recorded.
But that technology is available at the commercial court, so we could use it if we wanted to, isn't it?
No, it is not as easy as that. The kind of technology we are talking about is not what you see at the commercial court. Indeed, that same technology is in the Supreme Court, but that's not the kind of technology we are talking about. And so,
let me announce that Gabi Asare-Chirdako is with us. Good morning and welcome to the show, Gabi. Good.
And so, clearly, the Supreme Court shut that down and said that they were comfortable with the conventional way of giving evidence. And so, we all had to go by that. Now, the trial has been set for 16th. For me, narrowing down the issues to just the two, as I have stated, if I were the petitioners, I would withdraw my petition. Why? Because it is a tall order. It's going to be a mountain for them to be able to climb, for them to establish that these irregularities, if they were at all, substantially affected the results.
Did the court use the word substantially affect the results?
But that is the basis.
No, it did not say so. I've heard it said. I've heard some suggest so on other network, but I think it didn't say so, and I think there's reason why it didn't have to say so.
No. Everywhere there would be, when elections are conducted, there would be irregularities. But the magnitude of the irregularities is what would determine whether it had the potential of altering or changing the scores.
But for now, the issues before the court, the two issues, the second leg of the issue is whether or not those alleged irregularities or violations, if indeed they exist, did affect the outcome of the elections.
Exactly. And in clearing that hurdle is to say, would that have changed the results? That's all. That's the bottom line. Now, nowhere in the world, and I can invite Gabi, who belongs to a research institute, to make that research for us, that when issues are narrowed down to these two issues, nowhere in the world that an election petitioner has won on those two issues.
Why don't you want to wait to cross the first hurdle?
No.
To establish whether indeed there were irregularities, there were violations or
the second one
so
is of importance. As for the first one, I have indicated that there's nowhere in this world that there are no irregularities when elections are conducted. You cannot have a foolproof elections. The second one is what the crux of the matter is. And all over the world, be it in Florida, be it in Kenya, be it in almighty Zimbabwe, when the issues are narrowed down to this, you are sure that the petitioners would lose the case.
So it's a very serious statement, Gabi, that he makes, that if he were the petitioners at this point, he will withdraw the petition.
Well, thankfully he's not, is he? He's not. So I think he should focus on his defense. I mean, rather than thinking for the petitioners. And I'm not too sure where they're thinking. What does it mean by nowhere in the world? In Ukraine, it came to that.
Those were not the issues. I'm saying that where the issues have been narrowed down to these two issues. Those were not the issues.
Please. The issues were the issues. In Ukraine, there were people who were not supposed to vote and voted. It came down to numbers. After all the violence or whatever, it came down to numbers. In several cases in Nigeria, where governors have fallen because they didn't have the numbers. And you see, the point is, when you look at all the case law, let's just even focus on Africa. Being it Kenya, Uganda. In Kenya, when they looked at the 22 polling stations, they came up with just about 6,000. And it required over 8,000 to actually let Uhuru drop below 50%. So they didn't get the numbers. It comes down to numbers. In Obasanjo's case and the rest of them, they found some 1 million numbers. The difference sometimes about 10 million. It comes down to numbers.
But you would appreciate, as he says, that the substantial nature of the numbers is important.
I'm coming to that. In Besigye's case, okay, he was alleging that over 1 million votes illegally went to Museveni. They found about 200,000 numbers because the calculations were based on some speculations and the rest of it. It's down to numbers. And when you look at, if he's talking about numbers and he's looking at the petitioner's case, let me just take one ground, for instance, okay? The issue of overvoting. Now, what is overvoting? There are two categories of overvoting. I really don't want to get into the merits of the case, but I think he has really invited me to do so. But I get to just the petitioner's case. There are two categories of overvoting. One is that the number of votes cast is more than the number of people on the register. And that's part of the petitioner's case. Two, that the number of votes cast is more than the ballots issued. That's also part of the petitioner's case. And there are nearly around 900,000 of such votes. Just overvoting. And the thing about overvoting, Thompson, they directly lead to the declaration of the results. Because those are the results that are given to whoever the candidates are. Whilst we all heard on the 5th of December, at the press center, where even Afarijan came out to explain to the public what the rules are in terms of what happens if you find overvoting, that the results will be annulled. So if the petitioners are asking for just overvoting, I'm not looking at all the others, votes of overvoting on the face of the pink sheet, nowhere else, the very sheet upon which the declaration was made. And they found over 900,000 votes affected by overvoting. You take them out, it brings John Mahama down to 49.19%. So how can he sit here and say that the petitioner should stop and go home? Looking at overvoting alone, John Mahama drops to 49.19%. He doesn't make up the 50%, over 50% mark required to be elected president of the country.
But per your petition, you are seeking to annul a total of how many votes?
I'm just saying, forget about the rest. I don't even want to get into the details of voting.
You're seeking to annul at least 4 million votes.
I'm saying, I'm just taking his point and using just one.
I get that. I'm just asking for the benefit of those.
Just one of the grounds.
Yeah.
Okay? So let's not try and be the judge and jury on Newsfile. If you want to tell us what happened in court, please do. And also he's wrong in saying that there was a ruling that you can't use PowerPoint.
That was so.
That's his understanding. Let me tell you my understanding. initially the court came and said that they were proposing that all evidence shall be by affidavit, unless there's a compelling reason. It was at this point that Philip Addison, the lead counsel for the petitioners, got up and said, that is fine by us. But in that instance, we have, if you like, other stuff that we're going to do if we're allowed to come in the box. And these were like PowerPoints, audio visuals, and can we then attach to the affidavit soft copies of these? The president's initial reaction was that, well, you know, we are not like Kenya. I mean, we all saw the Chief Justice of Kenya having an iPad. You know, I mean, with all due respect, I don't see Justice Atugba with an iPad or any of the justices. So yes, he was fair to say, well, you know, we are not like Kenya. You know, he made that point.
But the judges, they use computers.
I'm coming, but he made that point. And then Sophia, and Sophia's point to me actually explains what it was all about. He said, look, some of us may be ICT compliant, but not all of us. So if you give us these things, it's up to us, because once you give the evidence in soft copy, because you have PowerPoints and all on them, video and the rest of it, they have to operate it themselves to go through it. And he says, well, so not all of us can do it, so let's keep it conventional. Now that request was based on a proposal from the bench that all evidence shall be by what? Affidavit. Eventually they came back and said that the parties can give oral evidence. Now, how does this affect a judge who is not ICT compliant? Because have they been, if like, invited to operate any gadget? If you have a Akufo-Addo, you know, who I believe is ICT compliant.
So are you suggesting that the petitioners will be seeking to use this technology?
I'm saying that the court did not give a ruling on that.
Point is we will not use you know, the technology in the court.
No, the court did not give any ruling on that. The court, it was based on a proposal from the court that evidence shall be by what? Affidavit alone. And then the court invited the parties to give, you know, their opinion on it. The respondents said no, they want no oral evidence. In fact, the lawyer to John Mahama went as far as to say no, that, you know, filing over 8,000 affidavits for, you know, will be too much, because just give us 5 to 10 minutes to bring 8,000 witnesses to court. Now that's about 80,000 minutes. But you know, he said it, and that's what he wanted. And the court said no. If we go your way, and that was actually in response to Kwasi Aida's point, if we go your way, this case, there would never be an end to this case. So by the time the court came with this order, there was no ruling that you can't go in the witness box to use PowerPoint. And in any event, that was established in the fast track court case, the quality grain case. Yes, he did PowerPoint. So it's nothing new. But it's new if you are given that on a soft, sort of on a pen drive, and inviting a judge to get his iPad or whatever, you know, his Power Mac Pro or whatever it is, to work on it. And she was saying that not all of them can do that. So make it easy for us. But if really, let's be a little bit commonsensical about these things. You are in the witness box to help with your submission. Okay, you want to do it by PowerPoint, which may even enhance the bench's understanding, appreciation of the case that you are pushing. Why would they say no to it? It never got to that point. So let's not just say, in any event initially, the respondents, when they had audiovisual, they were against it. But when the meeting took place of the parties, and it was explained to them that it was PowerPoint, even the respondents agreed to it. So it's not as if it should even be an issue. And please, let's give our bench some respect. At least they can appreciate it when points are being put on a PowerPoint.
Thank you very much, Gabi Asare-Ochodakun. We'll come to the other aspects of this particular discussion, but let me come to you. Again, we have had the use of affidavit, and no viva voce oral evidence. Testimony will be allowed in court. Mr. Ernest Thompson, take us briefly. When we say it is the affidavits that are going to be admitted, what exactly do we mean for the understanding of those who do not have the training in law?
Thank you very much, Thompson. let me approach your question from this angle. We need to avoid going into the merits and demerits of the case. I mean, as lawyers, we really need to avoid
we are required by the law not to do
that. I mean, others may do that out of ignorance, but as lawyers, we need to be very careful.
But first point, break it down.
About that.
Decode the understanding of an affidavit. How are they going to do it?
Let me tell you something. On the surface, it looks very straightforward and simple, right? But I don't think so. And in my discussions with my fellow lawyers, a lot of us share the view that...
What I meant, first of all, was for you to tell us, Evidence Law 101, or whatever it is, Civil Procedure 101. Tell us, what is this affidavit thing about, all about?
Basically, an affidavit, let me define it as a written statement given on oath and administered by somebody who is authorized under the law to administer such an oath. Okay. Right, and I think that when you go back to the CI 47, I believe that might be either Order 20 or 26 or something. There's a whole provision on affidavits and how to use it. And usually we use it, to support applications. But it also could be used as what you call affidavit evidence. Right, and I think it's the affidavit evidence perspective from which is at stake.
So, for example, if the petitioners wanted to call a party agent who was at the polling station, that party agent will simply put on a piece of paper and name himself and say that the matters that he's going to talk about, they are matters that he knows about and that they are true, and state his address of contact and everything else, and then start straight forward to say he knows that the elections were held on this day, he was there, he saw A, B, C, D, things went on well or things didn't go on well.
That's the very reason why I'm saying that the issue is not as simple as we said, because there are rules governing affidavits. For instance, it's very clear that you really have to swear to what you can prove.
That's so.
You get me? And you can swear based on belief and information, provided you can give the source of your belief and information, right? When it just opposes to the facts of this case, it's not as very simple as we say it, because what are the grounds which were limited to? Take us through the grounds yourself as the host. I think I read something about statutory violations. Yes. Right. That's a very big area.
Number one, whether or not there were statutory violations. Statutory violations, one.
No. The one who formulated, by the way, used statutory.
Yes.
But when the president was reducing it to writing, he didn't use statutory.
Okay.
I think what the president did.
Yes.
Okay.
Yeah,
so whether or not there were statutory violations, there were violations, omissions, irregularities, and malpractices.
And irregularities.
And irregularities.
Let's take the issue of violations. Violating against what?
Against CI...
against a certain law. Let's make it a certain law. Right. You swear an affidavit. You get me? Stating what? That a law has been violated. With which exhibit? With which exhibit? Because that's a realm of law. And that one, I can tell you, may lead to legal arguments along the line. Because if you call all the lawyers into the room today, and you ask them to argue on CI, the yellow one is the... Okay, that's the one
25.
The one containing, I think the 32.
The regulations,
is it the 32? The regulation 32?
Yes.
It's another area which can lead to a lot of legal arguments. Right, but I don't want to go into it.
I don't get you. A party agent was at a polling station, and some of them, as they told us whilst we were reporting the elections, that voting has been allowed without biometric verification. That's what he's going to say on the affidavit. What's wrong with that?
You know something? When you swear an affidavit, what do you use to attach to it? To prove what you are saying you are swearing to. To add as further evidence to what you are saying to.
You don't always need to make attachments.
No, but let me tell you something. When you just swear that I saw somebody, right, who didn't go to the, how do you call it? Verification. What are you going to do? List a whole lot of names of the people who didn't go through?
May I just help
you see, no, I'm only posing.
But I'm helping you. Let's not be. I think you've been too hypothetical. Now, first of all, the petitioners have limited their case to the facts and figures as what presented on the official document for declaration.
That's the petitioners.
No, yes. So I'm here. So
but that's not the court direction for the day.
No, please. Let me just.
Yes, okay.
Point. So really, we are talking about documented evidence or documentary evidence.
I don't have a problem.
So
that
is what it is. So
let me please finish my point.
Okay. But
let me
as much as possible, not to make it into a courtroom discussion, so our listeners may not be able to follow.
That's exactly what I'm trying to say.
Okay.
That if you look at the broad areas that they gave, irregularities, some form of violation, take one. I'm only taking one, like an ordinary person on the street. You get me? And you are swearing affidavit to show that there's a violation. We have all agreed that there will be a violation of something. Let's call it a certain law, right? Contemplate what you're going to say in there. And I'm talking now of practical practicing of law.
But I'm telling you are talking about violations. The person alleging violations. Okay, all the violations are on the face of the document.
That's what.
So why are you making this hypothetical argument?
Wait.
No, you're talking about violations. Proving a violation.
It's
on the face of the
Mr. Thompson, is your dilemma?
There are different forms of violation.
Is your difficulty resolved?
But the case.
Is your difficulty resolved with the counsel for the petitioner or the respondent doing the addresses?
No, what I'm trying to say, that the case as it stands now, it will be simplistic to think that mere affidavits will be enough to resolve the thing. I can foresee the court, as they've always done in the Supreme Court, asking parties to address it on certain issues. Legal issues will also arise. So I don't agree with Gabby's impression is creating that it is only a counting of numbers. I mean, I think it would be too simplistic to think that way. Now, beyond that, setting the petitioner's case may raise a lot of issues. Some of these issues may have led the court to come to irregularities, more practices, and the rest. However you define them. Now, as you swear the affidavits, 11,000 something polling stations. Am I right? Right. Which of the affidavits will deal with more practices? Which one will deal with irregularities? Which one will this?
No, is it necessary to do so?
No. You know something? To prove your case in court, you get me? To prove your case in court, I can see some little difficulty in that area, because you see, the problem in one polling station might not necessarily be the same in another polling station.
That's so.
You get me? But I mean, let's be very careful about these things.
You have been too hypothetical, and you don't seem to get it.
No.
I'm just saying. You said to prove the case.
I'm actually being realistic.
Please. Let me tell you. Look, first of all, I'm not too sure whether you've been following presidential petitions. Everywhere is done by affidavit.
I'm not saying it's not done by affidavit.
Don't create the impression that this is a very strange, complicated issue. Secondly, unlike many other presidential petitions across the world, the petitioners have limited their case to documentary evidence. It's not as if, oh, me baha, and me huwe. No, it's not about what I saw at the polling station. It's about what the EC itself has recorded on the declaration sheet, the pink sheet. So, your issue about how do you prove violations by affidavit, the facts are on the sheet.
No, I'm not saying I don't know.
So please, then refrain, then say. Perhaps
do you have the facts on the sheet in respect of people voting without biometric verification?
Everything is on the sheet.
On which sheet?
Look, how many times do you want me to say it? What sheet do we use to declare results? The pink sheet. and everything is based on the pink sheet. So maybe the difficulty you are talking about is about maybe the respondents, that they will come and say, well, what is on the pink sheet is not correct. You know, no. If you are telling me that the difficulty lies,
if you look at the answer
of the respondent,
if you look at the affidavit,
so what would you have preferred? Let's resolve your difficulty.
I'm not saying that the affidavit is not the best way out.
It's the way that is used everywhere.
What I'm saying
is that
it itself, you get me, in the courtroom, as a case unfolds, we'll say that it's not as easy as people are.
Of course, you said it's easy.
I mean, that's the point I'm making. So you actually agree with me.
But do you agree? Do you agree that this is the way to achieve expeditious
within
trial.
the circumstance of the case. Bear in mind that the Supreme Court, under normal circumstance, hardly goes by viva voce with evidence. Once in a while, they do it. You get me? Right. So anybody who's been in the Supreme Court will know that usually they don't.
Because oftentimes they don't do a trial.
Yes, often they don't do a trial. Now, within the circumstance, I think they've done a very good work by limiting the issues and asking them to come to affidavits. But I'm saying that I can foresee a situation as the trial starts, a lot of issues will come up. Let me also give you one. If you are supposed to swear an affidavit to prove what you are saying, it demands some personal knowledge, isn't it? Or some belief or something of the sort.
That is so.
You get me? I can foresee situations in which, when the affidavits come in, objections will be raised to certain people that look, somebody is deposing to something that he has no personal knowledge about, or the source of his belief cannot be. I'm saying that there might be some issues coming out. That's what I'm saying.
Let's get a little further with this. A party agent, and I'm foreseeing that polling station agents are the people who are going to be deposing to this.
That's what we are all thinking of.
So that's what we are assuming. Objection, for example.
No. That's what we are all assuming, right?
You and who? I'm not assuming that. You are assuming.
No. I mean, something is saying that. It's likely that polling agents will say. But who's going to do it in law? In fact, who is going to do it in law? Somebody who was in there. I mean, let's call it somebody who was in there. An auditor. An auditor can only tell you what he audited. Not what took place, what he was in there. I'm saying that there are issues.
But what took place is on the pink sheet.
Thank you. Thank you.
These things.
You asked the question.
Gentlemen,
how do we explain?
Let's hear him.
Yeah, how do we explain an affidavit to the ordinary Ghanaian? Because we've been using the word affidavit. And clearly, when we need to explain this to the viewers, and listeners. An affidavit is simply what a witness would have said orally, he puts it into writing. So what you have said, if you took the witness box, is what you put it into writing, and the court will take a look at it. So to reduce it to the layman's language, affidavit is simple what you would have said if you were in the witness box. You reduce it into writing.
If you are in the witness box, you would have been sworn.
Yes.
On the affidavit too, you are sworn.
Okay. And then the things you would have said in the affidavit, in the witness box, then you reduce it into writing. So you agree this will help to... Oh, I agree. This will expedite. Surely it will expedite. But it will give so much work to the lawyers. That I can assure you. At the moment, we are deploring lawyers all over. And it is too cumbersome. Yes. What makes it cumbersome? What is it? You have to, like you indicated, this must come from those who are eyewitnesses to the events. And so you have to go to Bunkurugu Yoyo to get that man. And then you have to deploy lawyers to go there. It's not any person who can take an affidavit. I have experience. So you join application. And so clearly, that's how cumbersome is it. It is. But it will expedite the trial in court. It just puts so much work on the lawyers.
And something you understand where I'm coming from. Okay. That look, if this is going to the position, this is going to be the position that the law demands, and this is a position the parties are going to take. Any slight slip on an affidavit, we didn't follow that, may lead some objection to that affidavit. That can be expected. But anyway. You also made a case, let me say, you made a point, I just want to explain something on the parties. Right? I think we need to get something straight. There's no legal rule that a party to a suit should enter the witness box himself. There's no legal rule. Yeah. I mean, let's get that straight. I mean, it was well established in Ria Shaliboche. You get me? It's an option you have.
And in any event, let's add to what he just said. There's no allegation against John Mahama. Okay. John Mahama is only a party because the law says so. Sure. So there's no allegation against him.
Thank you very much.
So he doesn't have to be in the box.
Now, Kuku, when you came to realize that the court had narrowed the issues down to 2 and has set a date, you felt relieved that soon we're going to get to the end of this matter, right?
Oh yes, a sense of relief, and I'm sure it's not exclusive or peculiar to Kwekubako. I'm sure it cut across the political and social divide.
Shouldn't be so sure.
No, I'm sure about that, because last time here we considered that it's not in anybody's interest, all the parties as well as the nation, that this thing gets protracted and that it becomes a journey to nowhere. I mean, so we were concerned about the apparent delay, which was, you know, setting in. And there were various reasons for that apparent delay. Some, I thought, within the competence of the Supreme Court itself, and some based on petitioners and the respondents, all part and parcel of that legal process. Whatever it is, here we are, we have a date, and that I think is important. But I'm not a lawyer, you know that. I try as much as possible to appreciate what lawyers see.
And you do well in your appreciation.
I'm trying. Unfortunately, 3 good lawyers here, and I've had to listen to them clearly. But my first instinct is that however complicated or challenging a situation is, it seemed to be within the competence of the Supreme Court to tackle it, to interrogate the issue. So yes, the lawyers have raised some challenging situations that may occur, and possibly they will occur. I mean, I don't think one should proceed on the basis that they may not occur, knowing what has even happened already that resulted in the delay that we're all complaining about. I can envisage a situation where there will be all sorts of tactics and things in the court, but I still believe those things are within the competence of the Supreme Court to tackle step by step till we get to the end. With the mind that we should, whilst I agree, justice delayed, they say is justice denied. I'm also told that justice rushed is justice buried. So the critical balance is what we are all seeking to
And
draw.
sometimes we say that delay defeats equity.
Yes, so I agree. But we should put at the fore of our mind that this is a critical issue. It's the presidential election dispute, and we are litigating over it. This whole country, within the context of the international community, needs to move forward. It needs to move on, put this thing behind it at a certain stage. So we can't, you know, tolerate too much delay. But there are still few things that came up. You know, see, whatever the results will be, the outcome will be, I think it will have far-reaching implications on the integrity of our election system. I do not see how a declaration will be made without a focus on some aspects of our election system and prescribing some cure for it. I look back to 1992, the stolen verdict, and the consequences of that situation, the boycott of parliament and the stolen verdict being written, leading to agitation for reforms, and all sides eventually coming on board to institute those reforms with international backing. I can see something happening relative to this dispute and its outcome, where we would all seek, because we don't have the luxury of an alternative. We can't use any other process apart from competitive elections to determine who rules this country. We've passed the stage where we used unconstitutional methods. To that extent, you see, there are few things that have happened within, and I'm not sure whether you permit me to move forward. Now, I'm clear in my mind that PowerPoint presentation was not outlawed, so to say, by any ruling by the Supreme Court. I happen to believe in what Gabi is saying. But the point about televised coverage, it looks as if they were definitive and not ready for it. I think that worries me.
The words of Atukuba was that, you know, is a good idea, but the grounds are not. You know, so that's basically.
I found that more worrying.
Really,
no, but I found that more worrying. We concede it's a good idea, but we don't provide the reasons why we think that good idea cannot be actualized, and that I find worrying. And I've heard people who normally are advocates of transparency, but are in support of this vote for conservatism. It's clear that the Supreme Court judges voted to remain conservative. But what is it that transparency here reflected in televised coverage, what harm would it do to the court proceedings? And this is not an ordinary court proceedings. It's a court proceedings based on presidential election dispute. So I have a problem there, and I think that, well, it may be too late for them to revise their notes, but the argument is out there as to whether indeed it would have harmed the litigation or the integrity of the process or not. I think it would rather have worked to destroy or undermine any mischief, undermine ignorance, promote clarity and in the interest of the public, let people follow the event. Whatever mischief people may seek to do with that cannot work because of the fact that it is a live coverage. I don't see how a live coverage can be manipulated. I don't see what people say about proceedings in court, however mischievous, could affect what we all see as happening. But if in the wisdom of the Supreme Court judges, they voted to remain conservative, that's their business.
I think they want us to rely on Asedu
But the parties are in there in the court. I suspect this is one of the reasons. The parties are in there in the court. Their various agents are also in there in the court. And
that's the danger. That's the danger.
Yeah, yes,
so
go
after
on.
court,
No,
and Asedu Ketia or Sir John will come
on.
and tell us what happened.
yeah, so in the end, the outcome is known to them. The process is known to them.
So what would the additional effect of a televised coverage do to that? If you are saying that their presence in court itself is a guarantee for the integrity of the process, that's my I didn't finish. It's a public. That's a good point. It's a public place. So what would further publicization of a public event do? I'm asking that what harm would the publicization of a public event do? Let somebody answer that to me.
You see,
That's the question I'm asking.
So this is the point. The fact that there's no live telecast does not mean that there will not be transparency.
I didn't say that, but
You
I
get
said
the
what
point.
would transparency
Now-
do?
I think Koku is talking about the additional benefits.
Yes.
So
That's the
fine,
point.
for
Thank
me,
you.
the argument should be that it will enhance transparency.
That's exactly what I'm
Not
doing.
to say that will lead to transparency. There's already transparency. Up to this point, nobody has had a complaint against the Supreme Court. Indeed, journalists are there. They come out and report. And so far, the Supreme Court has not even raised an eyebrow.
So what you are
as
saying
to
is
how-
not in opposition to what I've
yes,
said.
as to how the reportage has been. And so for me, the court is a public place. You can all go there. I admit that the space is too small,
Yes.
and so you have to be accredited. But nonetheless, it's still open to everybody. Everybody can walk in there.
It is not.
But because it is so limited,
It's not.
that's why they have to. And on a normal court day, in the Supreme Court, you can walk in and sit
No,
down.
but this is not a normal court
That's so.
process.
So because of the
There have
interest,
times I've been there, try to enter.
I agree
when
with
I'm
you.
fully robed
I
and I don't have the
agree with
opportunity.
you.
I see
I
lawyers,
agree
even
with
some
you.
lawyers
I agree
who
with
are
you.
coming from the law firms of the petitioners or the respondents who are denied.
yeah, because of the small
entrance.
space. But I think that with the televised television, that would have enhanced transparency. But that is not to say that the sitting will not be transparent if there isn't any television.
That greater transparency could help to undermine mischief, ignorance, and any malice.
Let me hear from Gabi before I come to you. Gabi, you started this crusade earlier about having the cameras in the court. You feel very disappointed that this is not going to happen.
Well, first of all, I'm not so sure if it's a definite no that I don't know, because just listening to the presiding judge, and him accepting that is a good idea, but was worried about the grounds. He didn't explain what the grounds were. I mean, to me, that itself is not definitive. And we all saw what happened in Kenya. Okay, Kenya was very tense. Civil society, the clerics, everybody was active in getting people to understand what was going on. And the court itself took that proactive step. And it's not safe. Kenya is like Ghana. Court proceedings are not normally, they are not televised at all. But in this case, they did so because they wanted the greater number of Kenyans to see and hear what's going on. And once that happens, then it minimizes the opportunity for propaganda. Because today, now what is happening now? After court, parties will devise how to spin it, and then you get a general secretary, I'm not too sure where he learned his law from, will come out and tell Ghanaians what happened in court. And you can always tell from it the spin. And sometimes also, elsewhere, I mean, trained journalists in the legal, whatever, will be the ones who will be telling us what happens in court. But what happens here in this country is usually the radio stations rely on the parties.
I'm taking a quick break. I'm taking a quick break.
And that is service danger.
We'll return to answer the question, what really is the danger in that? And also the question of expeditious trial. There's also some who suggest that it may be even unconstitutional, as it were, not to allow everybody access into that court. If that cannot happen, television will be an extension of access into the court. We'll be right back. You're welcome back, and this is Newsfile, brought to you by the kind sponsorship of Star Assurance, your solid partner, and MTN everywhere you go. I was coming to you, Mr. Ernest Thompson. You had some views to share in respect of the question about non-telecast of the proceedings and the danger that could pose.
Yeah, I think that, like my friend said, once we are educating the public, we need to clear certain things, right? The audio side wouldn't have been a problem. It's not a problem because that happens already. The audio side, because when you are in court,
it happens in the court and for the court,
yes,
for its records.
Yes, the audio side is there, right? Everything is saved from the commercial court and the rest.
It's not allowed giving to journalists to publish. That's the thing.
No, wait. To
rebroadcast.
The audio side, so far as the court is there, it's already there. The PowerPoint presentation is just a medium by which a witness wants to give evidence, right? The issue there is that how will the court receive it, and what weight will it attach to it? Then there's the issue of the televising, which is the live coverage, which, strictly speaking, is meant more for the public than the court, because whether it's televised or not, the court does its work. The pros of that is that maybe transparency, we are all seeing it. But something, going through the minds of the judges, and that's what we can only do now. Go beyond the reason that they give. And I remember one judge saying that, oh, we were training it, but we were not giving the facilities. But going through the mind of the judges, what I can contemplate happening is that, what happens when we are televising the process, and the lights goes off, and the television process stops?
Let that happen.
No. I'm posing questions for us.
Don't have a generator.
Oh, in the course. Don't go there. Don't go there. No. I don't want to say. I don't want to go there. No. I'm not saying that. I've not answered your question. You get me? I've not really answered your question. But what I'm saying is that in this country, any small thing, somebody will put his own interpretation to it.
So better to have the live telecast.
That's why I'm saying that. That's what I'm saying. I'm looking through the minds of those who say, look, we don't want all these controversies.
The question I'm asking,
just bring your evidence.
The question I'm asking now is that, is that not the reason, the more reason you should have a live telecast so that everybody will see what is going on?
No, the point I'm making is that, you get me? I'm just going through the minds. I might be wrong.
Why don't you go through your own mind and work?
You get me? Wait, Gabby. There were those who took the decision. You get me? And you are asking me a question, right? Whether we should have gone to, and I'm saying that from the transparency side, yes. You get me? But from the other side, knowing the nature of this country, this whole televising stuff will be hijacked and becomes another issue.
Beyond the transparency side, how about managing the acceptance of the outcome? Is it not important to have it televised?
That will have to be a process we have to go through.
I mean, if you have it televised and people follow from day one to the end, does it not help in accepting the outcome?
No, nobody's doubting that. You get me? But I'm saying that in this country, and the way we are so partisan, right?
More than Kenya.
People put in so many interpretations on so many things. So for me, the Supreme Court approach, despite what they say was that, look, just bring your evidence. We have enough there to handle the case for you.
Just 30 seconds, Samson.
And I do agree with him.
Let me give you a typical example of what happened. What happened last Tuesday? After court, Asempa Kaba was hosting the program, and he called Asiedun Katia. And I heard Asiedun Katia, the General Secretary of the NDC, say that the Supreme Court has no powers to say that John Mahama should step down and Akufo-Addo should become president. He has said that publicly, okay? And his supporters have heard this, okay? But you and I know that even in CI 74, when they show you how to fill the forms, Form 30, it tells you that the reliefs you can seek are that the person declared is not the validly elected president, and that somebody else is the validly elected president. The rules themselves show you what you can do. Yet you had a general secretary of a party going out publicly to tell his supporters and the rest of us that they can't do that. So what happens if the Supreme Court does that? And, you know, so it's important, but I'm saying, you know, it's important that we find a way to prepare the minds of the public to the possibilities that can come out of this court.
You've already written extensively, and you say that the outcome, no matter what it is, potentially can bring some problem.
In the absence of we preparing the public. And we had Emmanuel bombarding me with all sort of things that I'm the one who is causing problems.
So what you're saying is a threat to the democracy.
He is a threat to the democracy because he is part of the National Peace Council, isn't he? And they've been quiet. They're behaving as if they've taken residence at the cemetery.
But is there evidence to show that people are preparing to disagree with the Supreme Court decision?
I'm not
There's
saying
no evidence to show that there's a group of people who are sitting somewhere who are preparing
when you have the general secretary of a you have a general secretary of a party.
Viewers and listeners can only make sense of what you say if you allow
my voice is louder.
Everybody to speak one after the other.
Yeah, so in reaction to what he has said, what Bombandi was saying is that, look, there's no evidence to show that there's a group of people who are sitting somewhere and planning to disagree with the Supreme Court decision.
Was he talking
for you to then say that? For you to then say that
he should make the
Peace Council should prepare the minds of people to accept. Who doesn't know that when you go to court, it's either you win or you lose?
What do you say about this?
So what about elections? Why did we prepare Ghanaians for the elections?
Who doesn't know?
Who didn't know that when you go to elections, you win or lose?
Gabi, what do you say about this? Now, the minds of the supporters of both parties are being fed with different positions. I've heard, for example, the NPP Samuel Awuku say consistently that by December, this country will have a different president. Now we have the Economist Intelligence Unit suggesting that John Mahama will run the full course of his term. How do you situate that in what Gabi is saying?
They are entitled to their views. Indeed, nobody goes to court and hoping that he will lose. Who goes to court? In the first place, when you go to court, it is your expectation that you will win the case. That's why you went to court. And so it is their view. Awoku can even say that tomorrow they will bring Akufo-Addo to the Flagstaff and remove John Mahama. He's entitled. The economic...
Can he say that really?
He's entitled to his view. That's my point. And so the point is that if pockets of people are wishing that things come their way and then the Supreme Court should pronounce in a way that they will be satisfied, there's nothing wrong with that. Point is that leadership should be seen making comments that would bring about unity. As in the case of
as
in the case of Raila Odinga, when he swiftly came out to accept the verdict and said that he is a Democrat and he thinks that the rule of law must prevail. That helped in quelling any other disturbances.
Even
that
then, over five
get the point. So for me,
but the Kenyan example, the Kenyan petition hearing was publicized, was televised.
And even there, five people died.
No. But I've indicated to you that the fact that there's no television coverage does not mean that our judges will not do a good work.
All right.
Nobody's saying that.
Koku, finally.
Bombard is somebody whose opinion I take quite serious. I think he's good in the field where he is. There's no doubt about that. So I listen to him carefully and usually take a lot from him. But for once, when I heard him tackle Gabi's thing, I was wondering whether he had taken his time to read the full text before reacting. Because sometimes the radio stations call you, they quote 2-3 paragraphs, and then you are invited to interrogate the issue. You are not careful, you can get something wrong. So I asked myself, because I recall 2008, June, when the court, the High Court, convicted and sentenced Mr. Chachu Chikata. I recall an interview he granted to 2 or 3 radio and television stations. And I'm talking of Bombardier. I was even intrigued with what he said. I remember him saying that the timing of the High Court ruling had the potential to undermine the stability of the state. We're talking here of an individual who was in court. The state was prosecuting in court and had been in court for almost 6 years. And the court had arrived at a conclusion. And he still thought that that conclusion could have the potential of destabilizing the state. There was a free Chachu movement, of course, out there campaigning for his freedom. And there had been some politicization of the issue. And he thought that that thing had potential. So he thought that the timing was wrong. Here we are dealing with a presidential election dispute that involves over 10 million votes, that is voters. And people are agitated about it. Some of us are okay. I've heard Nanado say when whatever the court, he will accept the outcome. I heard the president also say so. And some of us here, perhaps, I believe, have the same mindset. Many of the guys out there in the streets may not have that mindset because, one, based on ignorance, or lack of education and knowledge. So, for me, I vote for those who are saying that whilst the process is going on in court, and whilst all of us will abide by whatever the outcome that is prescribed, especially when there is no review in this case, we ought to take steps, especially the civil society groups, the peacemakers, to do things, to drill people, to build the mindset, to know that, look, the Supreme Court is vested with the authority, the jurisdiction to rule on this and do so. And so if they finish, let's not go out there and say we are challenging it.
Right.
I believe there's absolutely no harm in a call for people to engage in some public conscientization for people to accept the verdict. I believe there's no harm. I don't see how that is a threat to stability.
So the thing about televising, all of you appear to agree in principle that this is necessary. What steps do you suggest should be taken to sort of bring some pressure to bear on the judges to understand that this is important for the country, that the majority of the people want this to be done?
I'm not sure.
No pressure should be brought to bear on the
I'm not
judges.
sure.
No pressure. I think that this kind of advocating for pressure is not acceptable. Up to now, the judges have distinguished themselves. In their wisdom, they think that live telecast is not an option now. So what we can do is to err on their side and allow them to let the process roll out. For those who are
let's understand, the journalists who go to the court, they can't even record and play back. They can't record what is happening and play back.
Yes. But you must have journalists who are able to give accurate reportage. And that's what you have been paid for to do in this house. You get the point? And so if you go out there and you are not able to come out with accurate information, then you should be fired. Just as how you
I admire the faith you have
on the journalists.
Yes, I've heard journalists.
A lot of faith in us.
I've heard journalists, and you can't blame them. I've heard them, and sometimes it's a very fundamental misunderstanding or lack of appreciation of the process, and they give a certain reportage, and it's substantially flawed.
It boils down to the lack of training. In the, some jurisdictions, there are specialists in terms of reporting on legal matters because he himself would have some legal training. And so maybe our media houses should now begin to look for people who have such background.
Okay, thank you very much, gentlemen. I've got some text messages coming in here to share with you from the many people who are listening to us this morning. This is Newsfile coming to you live from the Multi TV studios. This is your Joy News channel. We are also live on Joy 99.7 FM and on radio as well. Kelly Muhammad Musa in Nalerigo writes, Northern region, from the Northern region, he says, Gabi's argument is too simplistic. The case will not entirely proceed on counting of numbers. The way the Supreme Court has narrowed the case to 2 issues make obvious that the petitioners are chasing ghosts. Okay, thank you very much. Samuel Brian Boabeng writes from Awoshi, the NDC think tanks should spare our ears with their bogus Montessori interpretation of the Supreme Court proceedings, because the court is different from Cantata Studios. Okay, just make sure that you can make your point without sounding, insulting, I beg you. The Supreme Court of Ghana would not hesitate to throw out the case which Nana, Jake and Baumia are contesting the validity of the results. It was free and fair elections. Thank you. You are done with your verdict. Atu Edu writes from the USA. The media window dressing of an election petition before the Supreme Court hits me in the wrong way. Suddenly, politicians are predicting the verdict based on their leanings, and I find it unnecessary. Nana Akufo-Addo believes in the legal process, and it is only commonsensical that others do same. Albert writes from UK, if TV telecast is not going to be allowed because it will show their faces and put their security at risk, what about radio telecasts which do not show their faces? Okay, so you're thinking that's what the judges may be afraid of. Kwame Kodua writes, Counsel, let it be known to our very senior Thompson that these days the commercial courts run on generators. Kingsley Kofi Kakari writes, it says, Samson, common definition of affidavit, and Ernest Thompson is fumbling. Oh, did he? It says, my goodness. Thanks for Amaliba, and Gabby is doing a great job. Okay. Okay, we certainly have to move to the other issues before us. I've got tons of text messages coming in respect of this particular matter. Thank you very much. Now, ex gratia. And in my introduction, I quickly thought of Alan Paton's book, Cry the Beloved Country. It appears the entire country is crying that this is not the best thing the best way to go. I want to find out from you what you think about the discussion so far, and essentially, should it be scrapped ex gratia? And I want to bring to your attention, the Constitution Review Commission said that overwhelming majority of Ghanaians were against ex gratia payments. And you can find this in page 180 of the Commission's report of December 2011. You had over almost 1,000-page document, and this is what they had to say. What's going on? I start with you, Gabi.
Well, I've been too busy looking at affidavits, so I haven't really followed much of it. Well, I think at the end of the day, there's a constitutional principle for ex gratia. There's absolutely no two ways about it. There's also the reality, and I think in balancing this is where the difficulty is. Was it in America just recently? Obama had to even reduce some aspect of his pay. It's symbolic. But there are things that perhaps one can do, like filing your tax returns 3 days late. That's still symbolic as a president. I'm telling you, it's still symbolic. And of course, forgetting to file your assets declaration, which is constitutional. So there are certain symbolic gestures that one can take. But at the end of the day, I think, considering the difficulties Ghanaians are going through, considering the agitations when it comes to strikes and the rest of it, considering the inflation, considering all that, the Dumso, they call him the Dumso government, the Dumso, all the difficulties, these things obviously don't go down well. You know, they have a similar problem just next door. They had to in Kenya, where I think their MPs are like the best paid in the world. They are paid more than European MPs as well, and they cut down their salary by 30%. What do? They have awarded themselves some huge ex-gratia, you know, about $25 million at the end of the day. You know, so to me, all parts of the debate. I mean, I can understand where the MPs are coming from. I mean, some of us can't see ourselves getting into Parliament. I mean, you wake up in the morning, then, you know, there are people with genuine concerns, your constituents with genuine concerns, and expecting you to deliver school fees and the rest of it, you know. And at the end of the day, of course, they get money to buy, you know, I've seen some four-wheel drives, brand new four-wheel drives, you know, I can see all that. So there's the combination of all these factors, but it is really, we must look at it again. Because if you have a situation where every 4 years, you were entitled to some amount of money for a job that you are still in there, I think it raises issues. You know, because, I mean, if really it is that when you are going out, we're giving you something, that's fine. But you've served the term. You are still there. I think we should look at that. I know my friends who are MPs will not like that. But I think really we should look at it. Because at the end of the day, why should a lecturer not get the same? Why should, you know, chief director? I mean, there are all sort of stuff that we can look at. Why should we treat our politicians differently?
And there are those who are also outraged learning that apart from paying the MPs, you know, rent allowance, when they are leaving, we also give them relocation allowance as well. And it's so fat.
Yeah, I mean, I can understand. The difficulty with the MPs is that, unlike you and I, the MP, if your constituency is let's say in Sunyani, back of Sunyani, in the north, upper west, upper east, or wherever, if it's out of Accra, you have to be going back and forth. You may even be a teacher at the back of Tamale, but now you have to come to Accra. Where are you going to stay? But you need to represent your constituents in Accra. Kweku Bako argues about MP's flats. I mean, sometimes I'm a bit uncomfortable with this sort of socialist thing, you know, but I think, you know, we must find a way that in Kenya they have a way of giving them money to go and get mortgage. You know, there are ways that we can do so, not necessarily providing them flats, but I think you know, the MPs are in a peculiar situation because of the geographical crossing of their responsibilities. You have to be in Accra, you have to be elsewhere, you know, and all that. We should look at that. And also, it's also the culture that we live in, you know, where people think that your MPs can answer all your questions. You know, if I have a problem like when I was in the UK, I have a problem, something to do with the council or whatever, I go to my MP. But I'm not going to my MP to say, I beg you, give me money to go and buy, you know, milk, you know, that sort of thing. But here, it is a bit different. And it's a cultural thing. And it raises, and because, I mean, some people might even just say that MP, you know, we're Miami. And because of that, yeah, too, man. You know, there are all these sort of, you know, so maybe we should all play a part in helping our MPs to do what they are elected to do and not to have the extra burden. Because going to funerals, for instance, I mean, can you imagine an MP not going to a funeral? And when you go to a funeral, are you not expected to pay something? You know, so there is that aspect of it. But beyond that, it still doesn't excuse, as far as I'm concerned, you know, you can't treat them exceptionally differently.
You just preempted my question partially, but you see, he's talking about the MPs having a lot to do, and we have heard them give that excuse. Even at the Constitution Review Commission, people went there, and some of the justification some of the MPs gave was that they have to take care of a whole lot of stuff. Is that justified? Is that the reason for which we should be paying them ex gratia?
Yeah, Sandra, let me say something. I mean, the reward for labor is also determined by the nature of the work the person is doing. So I get a little bit worried when people try to equate a certain type of labor, let's say university lecturers with MPs and the rest. Right. I think we need to get that straight. And because of that fundamental position in industrial relations, you are bound to have people having different types of rewards.
He's well authority.
No,
not on petitions.
Can we just try Fuman? Right. So really, you see, we need to guide against this type of arguments. I think the whole issue is the management of the whole thing, the timing of payments and the rest. Right.
Is that what it is?
Yeah, I mean, what I'm saying.
I want us to look at the broader subject of ex gratia,
which involves the management.
Article 71 of
which involves the management of the whole, the whole emoluments, right? And that's a broader picture, right? I mean, if everything is going well, right, how many people will even come and raise this particular issue? So there are undercurrents and undertones to this type of situation that we have in, right? What I would say on this issue is that we should rather think of how we're going to manage the process of those type of payments, right? And I really believe that, I mean, there will be much noise about this kind of situation. To me, the noise being made, it's got to do with the management of the whole process by itself, right? Because if you take a look at the issue of rental, really speaking, I mean, if an MP has to live somewhere and come and stay in Accra, that MP will surely need something, right?
Will surely need 50,000.
Whatever the quantum is very debatable, right? Because it depends on how you want them to live and where do you want them to live.
What do you say about that?
Basically, I think they should be treated well for them to do a good work for us. That has been my position on democracy. It's very expensive. And I tell you that as we move ahead, it's going to be more expensive than what we have now. But we should just manage the process. Talking about 50,000, I mean, what type of rental are you really talking about? What type of rental are you really talking about? Looking at the rental fees now, take areas like Cantonments, Laboni, and what are you really talking about? Yeah. But if you're going to look at their numbers and see the figures is too much, or you're going to look at them and see the figures is too much, the issue is that where do you want them to stay? Relocation. Right. I mean, look at the disturbance to their life. You understand me? But someone will say, oh, we didn't ask them to be MPs. But somebody ought to be an MP.
Actually,
right.
You know they even support their parties. They take money from source. The political parties, they take money from.
I mean, Gabi knows there's a lot happening there. Look at the S. Gracia Award, right? What really is the argument against it? Is it because some people are saying, oh, we are not getting something, so somebody shouldn't get it? Or is that they are not entitled to it? I don't think they are not entitled to it. Right. Looking at the nature of their work and the rest. Paying them S. Gracia Award. But the issue is what Gabi raised. That how do you manage it? Right. I mean, do you keep on giving them money at short notices and 2 years? It's the whole management of the issue which is really the issue, not the phenomena itself. I mean, to me, that's it.
If I'm paying my president 12,000 Ghana cedis a month, I'm paying the vice president 9,000. I'm paying a cabinet minister who is an MP, is it 7,800 a month? Plus. And I'm talking about this. I'm not talking about all the other things that go with it. And they are finished with their service of 4 years. I have to take so much of the savings and pay them as ex gratia. That is what it comes down to. Does that apply to the ordinary civil servant who is also, working out there?
But something, that's where I started from that. I have a problem with that kind of argument. You can take the president's salary, I mean, as a figure, but there's a lot of things which goes with the presidency, some of which are not written. You understand? I mean, that's an argument the MP will make. You can come and compare the MP to a civil servant, but the question is that what he's doing, the nature of his job, is the same as that of the civil servant. So those type of comparisons, to me, are not based on the same level.
Let me hear from you, Kweku.
Why do you say those
the MPs, I sometimes personally I don't get it. They have the MPs Common Fund and all of that. No, and so they talk about having to, put their hands into their pocket and give out monies. What are they talking about?
Well, the MP's common fund, I'm not sure can be applied for, you know, an MP's personal contributions to individuals and people who come to him. You can't do that.
The justification they are giving is because they spent for other people.
They are part of it. It's a self-inflicted problem in a way, as well as a reflection of our political culture. One, when you are campaigning, some of the things you promise to deliver gives the impression that you are capable of being an agent of development. Meanwhile, the constitutional arrangements, the structure that we put in place makes the district assemblies and the others as the agents of development. So there's a conflict out there, but it's been so in terms of our political culture for years, I believe since independence. So we're trying to cut, you know, a certain balance. That's part of the problem. So common fund really shouldn't come in at all, because even the way it's handled, you know, I'm not sure any MP takes the money personally to go out there to deal with the issue. No, but the focus is on ex gratia. That's, I think, where the focus is. In principle, I am not opposed to giving ex gratia. It's how we've handled it. You know, we've made it an emotive issue. We've played on the keyboards of people's emotions. Some people who are part of the leadership of this country threw this subject matter out there into the streets once upon a time and made it an object of street agitation and propaganda mischief. You know, some of them today are in government and are suffering the consequences of that action. And I'm recalling 2009 particularly, the way we went about the Chinwe Hesse committee report and recommendations, you know, and did all sorts of things with that particular document. Set up the Yamson committee, created problems for that same committee. One even is wondering on what basis we are paying ex gratia today. Talk to the MPs across the divide. Some of them are unable to articulate a concise and precise position on the matter. They don't want to tell you actually the basis for even the payment they are having. Is it on Yamson? Is it on Chinwe Hesse? Was it a hybrid? Such fundamental things that public accountability and transparency require us to know. We do not know, you know, and many of them who are beneficiaries are not even able or are unwilling, rather, to make a disclosure. And so we've shrouded this whole thing into a certain mystery, and it's annoying people. So there's an explosive mix out there of mistrust, distrust, you know, anger, and despondency over the matter. Now, in a period of industrial agitation, I know it's not fair to do a relationship, draw an interconnection between the two, but it's been done. And it's been done because we have set an agenda of distorting this whole otherwise important aspect of governance. Look, this is a constitution, constitutional democracy, and I believe we are going to live with it forever and ever. As I said, we've all arrived at the conclusion that we do not want any other system of governance. So here we are. We appear to be focusing only on MPs, but the thing goes beyond MPs. Article 71, office holders, it goes beyond MPs. The ministers, the president, the vice president, the auditor general, the judges of the superior courts, all of them are in there, a lot of public servants. So it's there. Now, in terms of, because the focus is on politicians, the executive and the legislature, I would deal with that aspect. You see, Parliament, of course, it's only when we have coup d'etats and coup regimes that Parliament ceases to exist. And so perhaps that has also led to a situation where we have too much cynicism relative to the work and the dignity of Parliament. But I am a student of parliamentary history, and I just love Parliament. See, the nature of their work is transient. That is something we should not forget. If we are going to build constitutional rule and make it sustainable, we need to attract quality, competent people into politics. My focus is on the legislature. You need, and you have a situation where people would actually leave the private sector, where they even may be gaining more, attracting higher salaries and emoluments with allowances, and going into politics, and people say it's sacrifice. It's both. It's sacrifice and service and patriotism all put together. You need to create conditions where people who go into politics as well as become part of the governance structure relative to the legislature should be highly motivated as well as highly qualified, competent to be able to do the work. Parliament is not just a platform for propaganda and debate and shouts. Strictly speaking, if we are looking in the long term in terms of governance, and we want governance and the legislature to produce results, I know what I'm saying. There are a lot of people out there who will be angry with me, because you see, the matter has become too emotive. It's become more of a propagandist matter. So sometimes you need to have the courage of your conviction to be able to state the matter, and I'm saying so. So when you decide,
and I'm thinking people are speaking to facts rather than mere issues of emotion, because we are being told, we are told very recently that about 60% or more of what we generate is used to pay of the budget. It's used to pay salaries.
I would have dealt with this.
We just got to know that 39 million plus is going to the MPs at a time when we are looking for only about 10 million to pay teachers.
I was first establishing the principle. You need to establish the principle. Let us all see that we do not have a luxury of alternative in terms of making sure that we have a well-equipped legislature. Do we agree to that, or we don't agree to that? Do we want a legislature that is made up of competent, qualified, patriotic Ghanaians? Do we want that or not? I wanted to settle that issue. And if we settled it, then we agree the transient nature of their job, because it's based on elections, also is factored in. Look, these things, we didn't arrive at this stage just anyhow. Check the Green Street Committee report. Check the Chenrehesi report. Even check Yamson. And I believe Irama Adi. There are certain concepts that are common to all those committees' reports. And it's also based on some universal principles relative to other jurisdictions that have parliaments and things. So one has to be very, very careful when we are dealing with that matter. Of course, it is always within the context of the larger economic circumstances of the country. Excellent. So that is where the other aspect is, that how you manage the quantum, all those things are subject to proper analysis and assessment. But the way we've gone about it, that's why I began by saying that we ourselves have inflicted on this country a certain uninformed approach, uneducated approach relative to how to handle this matter. So here we have to be dealing with what Rawlings used to say, populist nonsense instead of popular science. Okay, so here we are trapped. Meanwhile, the truth is that MPs would need ex gratia. I insist on that. Okay? They need it. And we must give it to them. How we go about it is another matter. How much we give to them is another matter. So if we accept the principles, then I've heard some people create them, but who send you to go into politics?
Do you approve of how much they are receiving presently?
In fact, to be honest with you, the figures that are being thrown around, I'm not too sure what the figures really are.
We know roughly how much it is that they are taking. 211, 270, and so on.
And were they paid in bulk? One lump sum?
It doesn't matter. That's the money they are getting.
Yes, but we must find out the criterion for it. What is the basis? How much is their salary? What were the service allowances and things? How was it consolidated? We need to do that. We haven't done that. Figures have been thrown out. And you see, at a particularly, if you like, bad time, quote unquote, because of the industrial agitation. I'll be honest, because the context, the environment within which this particular matter was introduced has made it difficult. But we need to have, as I say, the courage of our convictions and dispassionately bring this matter to the fore and discuss it.
Abraham, do you subscribe to the suggestion that this is okay, our economy can afford it? And we are not talking only about the parliamentarians, unfortunate, but we know that recently they had salary, raise, and it was backdated 4 years back. And all of this, people are thinking that, you are just taking too much from the taxpayer.
For me, Samson, politics is about the improvement of the lives of the people. And so when you choose and elect to go into politics, that should be your guiding principle. That you don't go there to enrich yourself. And if you want to enrich yourself, you go into the private sector. And so people who elect to go into politics must first have as their primary goal to serve the people. Now, I agree that you need to attract qualified and people with the right acumen to go and serve the people. And so you may have to bait them or trap them with some facilities. But the problem I have with this particular ex gratia issue, and for me, I still have that same stance against the earlier ex gratia and the Chinrehese, is the quantum. Because you don't want to. No. I will be consistent. I will be consistent.
What it means,
you see,
is that you reject it.
I will make this argument.
Objection.
I will make this argument.
Something of that.
Because you look at it, you look at the difference between what, say, a teacher who has taught for 30 years will take home as Senate, and then you look at what the MP will take home after just 4 years. That gulf is so huge that one cannot appreciate why that should happen when you live in the same country. And so it has to do with the quantum. There's nothing wrong with giving ex gratia to somebody who has served as a way of saying thank you. But if ex gratia is going to be seen
the other question people are raising is that thank you for what? That they sitting there in the house, the MPs, they make a lot of mistakes with some of the laws they need to take care of, some of the agreements that are brought before them. They mess up with them. So what are we saying?
And I have indicated to you that is why we need to attract people the right acumen to go there. So these thank you offers are good to attract qualified and people who will not go there and make those mistakes. So it is important to have that type of bait. And so for me, the thank you should just be something, because the MPs are also one of the best paid in this country. They are some of the best paid public servants in this country. And so if you are exiting, then you have to take this huge amount and go home with it again. Then people will also sit down and say, no, that amounts to robbing Peter to pay Paul. And that is where these agitations are coming from. But I have nothing against the ex gratia where it is meant to say thank you, but where it is also seen as another minefield, another goal for you to dig, then that is where the ordinary Ghanaian will begin to raise eyebrows. I also agree with the timing that we could have postponed this a little.
And pay later.
Yes, and pay later. And you pay later,
and pay later.
A reduced paid later.
Okay.
Yeah, exactly. So payment, you see, Gabi, you see, if you think democracy, and I'm pointing at this yellow book because that's the democracy there, is expensive, then you have to try dictatorship. Because we will need to roll out some of these facilities to ensure the stability of our democracy. And so democracy in itself is expensive, and you must understand. If you do not go that way, then you will be opting out for dictatorship, and that's not where we want to go to.
We should also create jobs, so people will have the extrinsic
and so for me,
benefits of democracy as well.
What we should be looking at, in summary, is the quantum and the timing. The white paper you talked about, that the CRC report, fell short of calling for the scrapping of the ex gratia. Indeed, what they said was that there must be an independent commission where we will have to take it away from the president, who appoints 5-member or 2-member committee to look into it. And when we
let me just read that portion for you. I'm reading page 11 of the white paper that government issued in June 2012 on the Constitution Review Commission's report. It says, government accepts the following recommendations of the Constitution Review Commission. A, the Independent Emolument Commission be mandated to determine and review all the emoluments of all public officers to accord with the job description and prevailing economic conditions. And B, the Fair Wages and Salaries Commission and the Single Spine Salary Structure should form part of the institutional structure of the Independent Emoluments Commission. Does it not tell you in very emphatic way that there's a problem, they have a problem with the ex gratia as we have it now?
They didn't say they have a problem with it and so it should be scrapped. What they are asking for is restructuring, reviewing it. And indeed,
reviewing it, and the underlining words are prevailing economic conditions.
And that's
they are talking about fair wages and single spine salary structure.
Good. So that supports my argument that you need to take on board the prevailing economic conditions. And when you look at the economic conditions, this quantum does not support it. It does not. And so with an independent body, they would be seized with the authority to be able to, you know, as it were, look at these matters dispassionately. And when they say the president will have to take home this, nobody can influence that. But when you have a president who has to appoint, and then, you know, it's now, I scratch my back, you scratch my back. It's the parliamentarian who have to approve of the president, and the president will have to approve. We are human beings. If I were the president, I'll also scratch the back small. So, indeed, if we take it away, as it is now, from the Constitution, and place it in the hands of an independent body.
Who appoint those on the independent body?
No, when you appoint, because you have no power to fire.
The president will appoint in consultation with the Council of
Exactly.
States.
But because you have no power to fire indiscriminately, those people would assume that independence and can speak their mind.
But is it for them? It's really what they are doing, is it for them?
Which of all?
No, the members of
the Emoluments Commission.
Yeah, it's not for their benefit.
Yes.
So why can't they do what they have to do?
No, but they have guidelines. They are thinking about, for example, they are thinking about the prevailing economic conditions. They are thinking about fairness of the wage and looking at it in terms of the single spine that everybody is supposed to enjoy.
But Gabi, if I have the power to appoint, a committee, and I look in your face and know that you are not going to recommend a certain amount for me, I just go for Ernest Thompson to head that committee.
So that's what the president is doing.
You are being mysterious.
No, you can't make you.
I can't reply Gabriel.
I won't reply him
because it's mentioned to this.
Yes.
You see, but sometimes you see, there's something.
Which things?
A lot of things.
Such
you know something. It's something. Let me go. You see, I think that's one issue we also have to bear in mind, that the whole constitutional arrangement for this thing looks like you scratch my back, I scratch your back kind of thing. And I see a trend happen, most of the time happening. These things seem to come up just when the budget has been approved and they have to go for the, is it appropriation bill?
Yeah.
You get me? Where the government now needs the money and the consent now to disburse. Right. And it looks as if there are certain things do happen now at that stage. That look, you have to please the MPs, right? Whilst they also get your things through. I mean, I've been seeing that trend most of the time.
Let's look at it this way. For example, you mentioned you justify the allowances that they get by referring to
that is a principle.
By referring to the discomfort they have to endure by being moved from one place to the other.
So I actually support the principle of ex gratia, like people said.
Look at it this way. There are police officers, there are medical officers who are moved all over the country. They don't get anything close to that. They don't get, you know, a percent of that. How fair is that?
Yeah, that's why I'm saying that. If you decide to compare labor to labor in this country and look at emoluments and remunerations, you get me? The word unfairness might run through everything. Start from what we went through, leading to the consolidation of salaries during the structural adjustment, to the single spine now. So there's that thing which happens in our industrial relations system already, right? So if that is going to be the argument for scrapping it, then I have a problem with it. So I don't have a problem with the principle of the ex gratia. My problem is, how do we manage it, taking into consideration the very structure to be put into place to determine what it is. This what the committee is saying. How do we manage taking into consideration the prevailing conditions at a point in time? Because the prevailing conditions are not static. As we move gradually, to a greater industrial country, maybe things will be far better than what we have now.
And that should apply across board if it's going to be benefit. People are going to benefit.
I mean, but unfortunately,
do you, for example, foresee these labor agitations cease when people know that this is how much some other privileged members of our society are taking?
No, not necessarily. Because to answer that question, you have to know what is the real cause of the labor agitations. Politicians will always let it look as if because somebody has been paid something. That's why some people are agitating.
The real cause is low salaries, wages, bad conditions,
I don't think
and all of that.
No, I don't think that's only.
And even
one
that
cause.
they don't get the allowances in time.
Something that is only one cause of it. The economic conditions at a point in time. You get me? It's only one cause of it of agitations and strikes, right? Economic conditions in South Africa, in the US, and the rest at a point in time leads to strikes. But there's more to it when it comes to agitations. Have you even taken a look at the labor law itself? You get the third party procedure in it, whether it itself not conducive to strikes, right? There are so many issues when it comes to agitations. But what I'm saying is that the politicians always want to have an edge over one another. So everybody's fast to pick something up and say, look, because you've paid this one, that's why the people are doing this, because you have paid this. But there's more to it when we're talking about labor agitations.
But my issue is there any money in the coffers? Because the bottom line, you know, is there any money in the coffers? I mean, we can sit here and talk about.
Have you seen the balance sheet of
Parliament itself? Parliament itself was quite recently. Parliament itself was given a check by the Treasury, and they kept telling them, "Hold on, don't cash it yet." You know, so we have serious fiscal issues. I'm telling you, let's not joke about it. This is not about politics. You know, there's serious fiscal constraints. Is that
really new?
No, my brother. It is new when you spend about 8.7 billion more than what you were supposed to spend.
It doesn't become new.
Huh?
It doesn't become new.
Because
it's happened so many times.
I'm asking you.
You didn't spend more than.
It's happened so many times in this country.
Look,
you didn't.
Let's look at the fundamental. Let's look at the fundamental issues.
But we are suffering from it today.
Okay. Kofi had his hand up for a while now. Let me listen to him briefly. Let's listen to Kofi briefly.
If you don't offer leadership and you think that televising a court procedure, you get me, will lead to something, you are not doing anything.
I see.
You get me? You are not doing anything.
I see.
You get me? You're not doing anything.
What's the logic here?
The logic is that we need to offer leadership.
Kofi, let's hear you. And again, Kofi, you were referring to all the commissions looking at best practice elsewhere and all of that. I mean, how do they come to this arrangement that this is best practice where?
Everywhere that there is a sustainable democracy, you have that situation. You consider the fact that you need quality, competent, qualified. I would add patriotic, but critical elements. You need them to be in government. And here, especially parliament.
So the best practice where? Is it US? Is it South Africa? Where?
Singapore comes to mind.
Countries is mentioned.
Yeah, Singapore is a classic case. If you go into the Chinrihese committee report, even South Africa, Kenya, and the rest were all referred to. I brought some of the reports here. They did extensive interrogation of the issue. They consulted many organizations, GEMPA and all the rest brought in input, right from Green Street. The 5 persons appointed did not just close themselves into a room to interrogate the issue. They opened up to the public, they received memorandum from so many areas, looked at practices in so many countries, and came to the conclusion. Of course, as I said, there's a critical element of within the context of economic circumstances. The ability to pay is also one of the principles they considered. And the fact that the jobs, in this case, are transient. And that you want to attract people who leave the private sector as well to come in there. There's an element of sacrifice to that,
quickly to the point for which you are calling my attention.
So we need to look at this thing in a dispassionate manner. Unfortunately, we've played political football with it, so it's become difficult. And this timing also has made it difficult for people to sell. But I'm saying that people should exercise a certain level of courage and speak to issues, even if it's unpopular, you know, so that we can actually demystify some of these matters. And that's the way I want to proceed with this. There's an element of unfairness somewhere along the line, and that also informs, I know, how some people take this subject matter. There are people in the labor unions who argue, that ESB, end of service benefit, was cancelled some point in time, and they agitate about that. They are not too happy with it. There are former MPs, especially those of the Third Republican Parliament. I think some of them are in court, who are insisting that they want their ESBs paid to them. So when all these things are brought in, then there's an element of a certain injustice and unfairness. But otherwise, if we can resolve all these matters, and if we can separate it, look at the quantum, check the basis for how we arrive at those things, and not throw the baby away with the bathwater, it will be in the long-term interest of the democratic
Someone in the
system.
CPP is suggesting that all MPs who do not reject this money should not be voted for in the next 4 years.
That is a campaign message he's selling. So it's up to the electorate.
It's a crusade.
Yeah, that's it. She's entitled to that. She should go out there in the field, campaign with that. If the electorate buys into it, fair deal.
We understood that Samia was not particularly, enthused about it. Do we know if she took it or she didn't take it?
I'd be surprised if she didn't take it, because she didn't announce that. She hasn't announced that I haven't taken it. And if she took it, I will support her.
Maybe out of solidarity.
No, she deserves to have it. Why not? I was surprised when public and
maybe in
said.
consonance with his party's stand.
A few text messages, and then we take a quick break here again. This one says that Nana Tewia NDC Eastern Region, in an interview, said they got annoyed with Ochihene because after the president said he will accept the outcome, some party members rushed to him asking whether indeed the president could lose the election, as they have been made aware by the the losing of the executives, that the losing is not possible. So live coverage is the best. That is a message from somewhere in the Eastern region. And his suggestion is that the executives have told him that losing is not an option. And so they were angry when the president suggested to the Ochihene that he would accept the outcome. So that's the question of ignorance also that Kukubako was referring to. Now, this one says, I personally think the NDC government led by President Mahama is not being fair in the distribution of the national cake. For Article 71 office holders, there is flesh on the bone. But for other workers, there is no flesh on the bone. It is very hard to chew. Adam,
there's not even bone to chew.
Adam in who writes, I want to know if MPs who are ministers receive MP salaries as well as ministers' salaries. That issue came up here sometime last week, and I think Akomia said yes, they do. But from the Irama committee reports, I think that is not the case. There was a certain rationalization that they get. Yeah, they don't. They get a top-up. Yes, they get just a little bit of a top-up. Ibrahim, right from where? I can't pronounce where you are. Vugu. That 2 billion ex gratia, it is too much. Okay, 2 billion, you mean, is it in Ghana cedis or what? Okay.
200,000 Ghana cedis.
Okay. Odum Idris writes from Bawaleshi, is it? Or Bojuase, that my father worked for over 20 years and his pension benefit was less than 10,000 Ghana cedis, and an MP goes home with 1 billion for 4 years. This is tantamount to unfairness and ripping Ghanaians off. Kevin says that for me, I don't care how much the MPs are paid, so far as it is legal and legitimate. If our transport systems are working, graduates get jobs, we have light, we have water, we have gas, we can afford the gas and other utilities, our road systems are the best, and all other workers are paid well on time, who will care how much MPs are paid? Absolutely. Mohammed's government has lost it. Why pay the MPs and the executive arm of government at this crucial time? Ado writes, I am not particularly against MPs ex gratia. However, I am against the payment in full of these monies while the president claims there is no money in the system. If the government can get money to pay MPs in full, then teachers' allowances must be paid in full. Theophilus writes, we do not vote for MPs to pay our school fees. They come and make promises to the people, and the people come to them for these things. We'll take a quick break here.
Actually, the president could have had a cheaper way, because they come for school.
You're welcome back. This is Newsfile. We're coming to you live from the Multi-TV studios. This is Joy News Channel, and you're on Joy 99.7 FM also. This show is brought to you by MTN everywhere you go, and Star Assurance, your solid partner. And I've got loads of text messages on the first issue that we discussed in respect of the election petition and matters arising. And there's a bit of it that almost skipped us. We want to go back to it briefly. In the course of the week, we were informed by that the Attorney General is not going to prosecute those officers who, in the northern region, were arrested for tampering or allegedly tampering with pink sheets. The Attorney General says that they have no case to answer. How does that not help the NPP's case?
To me, it's a shocking decision for the Attorney General to take, and I hope that suo motu, the Supreme Court itself, would want to look at this matter. Here you have, first of all, the Electoral Commission, in responding to the petition, where the petitioners are alleging that there were instances where presiding officers' signatures were absent on the pink sheet. And you know, it's a constitutional requirement. You know, the Constitution is quite clear that the presiding officer must sign.
Okay, you mean the act regulating the elections,
no,
not the Constitution?
The Constitution itself.
Not the Constitution. We are referring to
the Constitution, Act 49. Look in the Constitution.
Article 49.
Article 49. Article
I see.
49. Sorry.
Okay, so go on.
The Constitution is clear that
whilst we try to
a
look at
presiding
that.
officer must sign before he declares. So it's not something that you can take for granted. The Electoral Commission, in giving its original answer to the original petition, stated that, well, they did sign, but perhaps it didn't go through the carbon copy, which was really a strange answer, because every other thing can be seen on the face of the pink sheet, except the signature of the presiding officer. And then the petition is amended. It happens in Savelugu that a young woman, Saramatu, is arrested, citizen arrest. Even on the way to the police station, she calls her superiors to say that this is what has happened. She goes to the police station, confesses that she was given an assignment by her superiors to go out there and gather presiding officers to sign pink sheets. 2 months after election, pink sheets are still at the district level. Then her district electoral officer confesses that he was given the assignment by the deputy regional director. The three of them get arrested. In less than 24 hours, they are freed. And we even have the police saying that they were arrested for their own safety, and that the docket has been sent to Accra. The next thing we hear, okay, the Attorney General takes a decision that there's no case to answer. You know, for a serious country and for a professional Attorney General's department, when this matter is in court, and then you have what appears to be a chain of confessions, which may eventually lead to the top, and you have maybe a whole sort of web, whether or not there's a serious conspiracy or some sort of enterprise to not just tamper with the pink sheets, but pervert the course of justice because this matter is in court.
I see. And just for some information, I can confirm your reference to the Constitution, Article 40, Article 49.3 provides that the presiding officers will have to sign the declaration, as you said.
Absolutely.
But Gabi, you'd recognize that the AG, the AG reserves the power to advise what matter can be prosecuted.
But we need answers from the AG. We can't just, look, we live in a country of rule of law. We can't just sit there for a serious matter that is before the Supreme Court. Okay? And the AG thinks that she can just say that, oh, there's no case to answer.
But
and she won't explain it to us.
By law, is she required to give you reasons for that?
I'm saying that if she won't do so, I'm pleading with the Supreme Court to take it upon itself to look into this matter. Okay. Because, you see, it is actually perverting the course of justice.
Okay. Now,
for this matter to be let
Abraham, by law, she may not be required to give reasons for the decision she's taking. I think that may be the position of the law. But from what Gabi is saying, do you agree that it is good, it's expedient to have reasons for it?
First and foremost, the Supreme Court cannot be looking at a matter that's not before it. This is a matter that's so even with so moto, no, you can't be going out fishing for matters at the Makola market when people say something. This is Makola. No. Clearly, it's not within.
But so much they can call people they feel.
It must be
a kind of education
they feel are necessary to give some testimony.
No, if it were those further and better particulars that were exchanged, that is something before them. But this is somebody who is somewhere in his hometown,
Samson,
and you say no.
Let me come in 1 minute.
Now let me make my point.
Let me make 1 point. 1 minute.
Okay, just note it.
They amended their petition. They amended their petition. Okay, after Sevelugu, to come out to say that after the elections, they then sent out the return officers sent out for the presiding officers to come and sign. Because this exercise was going on.
You amended your original petition, and you don't think that they should also amend their petition.
Okay,
is that what I've said?
Now let's go to the
what
point.
Sort of logic
is
about
the AG.
You see,
when
the arrest was made, in fact, I was in Tamale, and I was called to the police station by a friend of mine. I had gone there to do a case, and I saw particularly this matter, with my eyes. Now, there were these MPP activists who acted as an agent provocateurs. Yes, they went there because there was a directive from the Northern Region EC that presiding members should come and sign their portion where they didn't sign. These activists presented themselves. They are the complainants in this matter, that they have come. They are what? Presiding officers. Now, when the lady brought the pink sheets out, they then pounced on her and did a citizen arrest. So that's how it happened. These are the facts. So they ended up at the Tamale Regional Tamale Police Station. They were charged with an offense of forging of official documents. Now, you know that in our criminal jurisprudence, the burden of proof lies with the prosecution. This matter was thoroughly investigated by the principal state attorney in Tamale. The Attorney General in Accra here, knowing how sensitive this matter was, washed her hands off. And I can speak with authority on that. Particularly because she also, before her appointment, was a lawyer, one of the lawyers to the president. So she stayed out completely on this matter. And so there was an advice from the principal state attorney in Tamale saying that the facts of the case do not support the charge and cannot be proven in court. Because according to him,
do not support that particular charge, or that a charge cannot be found.
Good. Well, I'll get to that place. Cannot support that charge of forging of official documents. Now, the next question you want to find out, which you have posed, is what other charge can we give them? And you know, as I also know, that you must charge somebody on a known fact and on a known charge. The charge must be known to our laws. I don't know which charge can be leveled against them. You get the point. So, looking at the facts of the case,
have you looked at Section 213?
You mentioned that charge. Mention it.
What are you referring to? Section 2 and 3?
Yeah, fabrication of evidence.
Fabrication of evidence.
No. A person who fabricates evidence with intent to defeat, obstruct, or prevent the course of justice in the proceedings commits a criminal offense. There's also conspiracy.
That's the alternative.
No, you wait. Let me take you one on that. Let me take you one on that.
And a person fabricates evidence if that person causes a circumstance to exist or makes a false entry in a book, an account, or a record, or makes a document containing a false statement or forges a document which intend to mislead a public officer, judge, or a juror acting in a judicial proceedings.
Okay.
You see, this is how the Criminal Offences Act defines forgery or forging of official documents. A person who, with intent to deceive any other person, forges a judicial or an official document, commits a second-degree felony. So now you need to look at the actus reus, the action, and the intent. These two must come together. Now, where is the intent that those documents were intended to be used at the court? Where is the linkage?
But we have moved away from there. He's giving you the alternative charges.
I'm not going to talk to him on these matters. So the point is that the charge could not be maintained if the AG actually goes on with this charge. And so because the accused person has no burden to prove his innocence, and that the burden is on the prosecution to even prove it beyond reasonable doubt. As for the accused person, he is just to cast a little doubt and you walk free. You don't expect a prosecutor to go to court and have his nose bloodied.
Okay, so this is to save him from embarrassment.
Embarrassment.
Okay.
So for me,
I meant this to be brief so that we could move on to the
yes. So that is why the Attorney General clearly indicated that there cannot be a charge against these people.
Okay, so the explanation has come.
Even though they confessed.
Koku briefly.
I think it may be, or may be true that it's within the legal remit or mandate of the AG to decide not to prosecute. I think this is an established principle.
Yes, it is within the power.
Yes, which we can dispute. But I think this perhaps, and this is a street opinion, is politically not a smart move.
You think so?
Yeah, it's politically not a smart move. And these are part of the problems, you see. So out there, a lot of people do understand.
But if the AG goes to court and loses,
no.
we'll tend to say that
that's why I said it's a street opinion.
It's
not an educated intervention I've made. I am telling you that if the court of competent jurisdiction had freed these people, it would go down better than. But this is not an educated intervention.
Mr. Thompson, briefly.
Yeah, it sounds more educated than one I had before.
Let me say that.
Gabby,
this is not the first time in this country that an AG has refused to do a prosecution.
Hallelujah. First for education.
Right. And I think...
Which AG are you referring to? Which AG are you referring to?
Oh, I can go as far back to Akins, who then became the Supreme Court judge. I remember clearly the commission of inquiry into the killing of the judges and what came up and what he said that, look, he wouldn't go and... I don't want to mention it.
But there are many cases that go to the AG that don't get prosecuted anyway, right?
Yeah. So
that's your point. But he's saying that this case
is
is such sensitive that you don't treat it like you treat
you know something. You see, that's the problem I've been having. Some people raise cases to a certain level for their own political gain, and then picture it as if it's as sensitive as it is. But you and I know that where issues of agents provocateur comes into cases, right? The position of the law on prosecution is something else. You get me? And from what you are hearing, it means that there might be a very good reason why the AG doesn't want to go ahead. We've not really, I've not seen the AG himself confess anything, right?
No, he's talking about the people who were involved, who were arrested.
You know something. You can't just in law say there's a confession, so go and prosecute. I mean, lawyers we don't act that way.
But there's a valid way to take a confession statement.
Yes, but why don't you assume for once that the AG might, and when I say the AG, not the person, the department might have done a good work, looked at all those issues, and have decided, like, within the circumstance of this case.
Why
you
should
get
he
me?
assume?
I don't. No, I'm saying that. I didn't say I assume. I said they might have done a good work.
All right.
Look, they are very good.
Dealing with you are talking about might.
Of course, because they would have looked at this. Look, they are very good lawyers at the AG department. You get me? And we shouldn't put our political desire.
But you should put your political desire
no, you shouldn't put your political desire beyond what the good lawyers at the AG are seeing. Right. I mean, let's give them some credence.
Okay.
Alice.
Thank you very much. And Gabi, someone saying that I think Gabi can be a great special assistant to the AG. His criminal law today is spot on, and he's not alone. There are others who agree that your position of fabrication is what falsification is what the AG should have looked at. But Amalba says he won't answer you on that one. But as far as he's concerned, the AG's position is a good position. Thank you very much. And like I keep saying, too many of the messages still on the election matter. But we need to move on, and let's go to the matter of the president filing his tax returns, and suddenly there is such a huge, clamor over it. What was that point for? I'll start with Kokubaku. The Constitution, we know, exempts the president from paying tax on his salaries and allowances. We know also that the Internal Revenue Law, Section 10, clearly exempts him from making same. But where he says he's earned income that is taxable and he's coming to submit to tax, why are we making noise about it?
Well, I'm not too sure where the noise was coming from, because I thought it was a straightforward issue. That if, as a vice president, and the Constitution obliges that he pays his tax. I know I've been doing some checks, and it's clear that his tax will be deducted at source. Okay, he falls within that context of an employee, so the tax is deducted at source and paid. Of course, the institution will have to give him a documentary proof of those payments. So, strictly speaking, in true terms, even the vice president, though pays taxes, is not really required to file tax returns in the real sense of the word, because of the category within which he falls. And then two, if he earns other income that is not part of the official income, in this case the vice presidential income, obviously he has to be paying tax and filing returns on that. So if he was doing that, again, I don't see the basis for any agitation.
The example you give, you're looking at, say, gifts that are chargeable.
Yes,
if he's getting a land
the sale of his book, the farm, the family farm, obviously he has an interest in it, so some monies come to him through the family farm, the farm that the father left.
15% and on gifts, and he's supposed to do so within 30 days.
Yes, so there should be no issue, but it's legitimate if people were to ask that, because he's gone public, that symbolic gesture, which is no substitute for any tax revenue challenges, but he felt like doing it in a symbolic manner. It raises the issue of people asking some questions. Okay, the content of what you filed, the sources of the income, and how much. These are legitimate questions. I'm told within the tax laws, he's not obliged to. In fact, even the tax officer who receives the document is not obliged. There's, is it 1271? There's a code of secrecy imposed on that tax officer. There are exemptions in 1272, where you could disclose to the Minister of Finance or his representative. A court order could order you to produce those things to an appropriate officer of either the Statistical Service or any other institution, and even a foreign government if we have an agreement with them in terms of double taxation and things. So there are exemptions. In this case, really, he's not obliged to. But you see, it's politics we are playing here. It's governance. And because he decided to do a public filing, and people were confused, the controversy all over the place, my view was that a disclosure of the sources, that is what constituted the other income, would not hurt him. I don't see how it will hurt him. He's not obliged to under law. And so let me make my statement very clear. I'm drawing that extension. But when it is politics, and it is governance, and you establish a certain style of putting out information, you necessarily must know that it will come with some consequences. And that is what we are confronted with. It is optional for him either to ignore the calls for disclosure, that is within his right, or to say that, look, I would cure this mischief in terms of the doubting Thomases or those who want to misrepresent the situation by providing the evidence. For instance, the sale of the book, how much was it that was declared? I have checked and I know, but I'm not entitled to do a disclosure because it's not my business. The farms.
It's public information. If you want to, you just go to the IRS, you get it.
Yes, but I'm not going to do that here.
GRA, is it?
Yes. You see, so, no, but I'm saying that there's a law in terms of how to do disclosure.
Okay.
They've stated it, the 1272. It tells you can only, if the Ministry of Finance, for purposes of financial laws, some fiscal laws, can get the information. The Auditor General can. A court order can. I mean, I'm sure there are people here.
You are not the finance minister, you are not the Auditor General, you've also not gotten a court order. So how did you get to know?
Oh, I'm an investigative journalist. You appear to have forgotten that. You understand? But it's unofficial investigation that you do. So to be honest with you, if we were to be fair to the facts and say that, look, even a president, if there's some income coming to him that is not part of the official income, I'm sure it's taxable. Okay? So really, I don't know why the noise ensued. I'll be honest with you. I don't know how it ensued. Because if you were to look at the facts as they were, there ought not to have been any controversy. Subsequent to the controversy, I had people who asked questions. And those questions, I'm saying, is within the remit of the president to do a disclosure. If he chooses not to, fine. But if he does, I think it would rather help his cause.
All right. I started with him because I've followed him elsewhere, and I discovered that he appeared to sound as if he had been taught by some of the greatest tax experts we have in this country. Now, immediately the people who came to my mind was Ali Nachia, who has a way of breaking the very difficult tax issues, and Asa Kumatu has an attitude to be able to do it that way.
This is one of my sources when it comes to legal education, and I actually called him to get some briefing from him.
They have a way of making the very difficult issues very simple. Now,
it was here 2 years ago.
Mr. Thompson, what's your take on what's your take on all of this?
I have just a few points to make about that. It was a symbolic gesture, and of course, in line with what a president telling us that, look, this is a responsibility we should have to take seriously, and I'm trying to do something for all of you to see where it's coming from. My only worry, and maybe it shouldn't be really a worry, is the fact that in this country, when these things have happened, for political reasons, you've got so many people raising issues, you get me? But they are not experts in that area. They don't have the knowledge in that area. They're not other finance, investment lawyers, or they're not tax experts. So when you hear people saying that, oh, why don't you disclose these things, and why don't you, it's obvious that they didn't know really what was in the law. I think Kweku has really said a little bit about what is in the law. That there's no obligation to disclose those details. Even the GRA itself is under some limitations when it comes to disclosing.
Okay, so
but if it's for political reasons, let's leave that for the president himself.
There's someone saying, okay, he's filing for 2012, so it's understood that at a point he was vice president, so he was not exempt. But at a point from July, he was president. Now, as president, there are some monies that he gets that are taxable. Nonetheless, the Constitution also makes provision that the president is not supposed to be holding any office of profit. So if he's gotten money from books it appears he's making profit. Is that not the case?
Are you now raising an issue of constitutional interpretation?
I'm asking you a question.
Right. No, I've only asked you that. You see, I mean, when people start talking about these things, you get me, then you are raising issues of interpretation, right? Which does not admit to very easy answers, right? But for now, I think that the president has not done anything, in my opinion, anything contrary to whatever we have in the Constitution. I think that he has done what a president ought to have done, and I think he's done it in a very beautiful manner. What we need to do, rather, is to find out how are we going to deepen those processes by looking at other officers and the rest holding key positions and what they are expected to do, even going as far as to declaration of access. Then we deepen our democracy, rather than picking a particular issue and then looking through the Constitution to find out is there a fault. I mean, we don't move ahead.
So once again, strictly your legal opinion again. Article 68(1). He should not be holding any office for profit or whatever it is. What's your understanding of the office of profit? For profit, or what's your understanding? What constitutes? Does writing a book and making money out of it, or having a farm and making money out of it, constitutes an office?
No. Vice president.
Okay.
68(1). Does it cover the vice president?
No, it does not.
No. Assuming even that, you get me. What was the intention of the drafters? Look at the words used. An office, you get me, which presupposes some permanent position. You get me, with some nomenclature and the rest, which income or emoluments do come in and the rest. It's not just like somebody writing a book, right? And then saying that, it's really writing a book. Is that really an office of profits, right? So that's what I'm saying that. When it comes to the interpretation...
From your understanding, it has to be, that's a structure. You are in an office, as it were, before it can... what you do out of it can attract tax.
You see, some say it depends on what line of interpretation you want to take. And you can never predict the Supreme Court now when it comes to interpretation.
Is there no interpretation already on that?
Yeah, you know something? I can, from my perspective, look at the circumstance of the case and argue beautifully, and I think I can do it, that he writing a book within the content of this Constitution should not be interpreted as holding an office of profit. Okay. I can argue that beautifully.
I'll try and look if there's
is there no precedent on that? I'm told.
Yeah, because the fact that the word office was used, you get me, denotes a certain situation.
Office of profit or emolument.
Yes, office of profit or emolument. You see, it's quite different from saying that don't do anything or get involved in any venture. You get me? That's also another issue.
Gabi, so this is good. Symbolic is good. Is encouraging, inspiring people to pay their taxes. What's wrong with it that we've been talking about it all week?
There's nothing wrong with it, but we shouldn't reduce governance to form whilst not tackling substance. And I think we have this proclivity of wallowing a lot more in form than flying away with substance. And to me, that's it. Yeah, you can go and strip and show that you are fighting the drug menace, but what have you put in place to make sure that it will work? We should go beyond symbolism. At the end of the day, go around, do a little research and go around some of these very beautiful places in Accra and find out who pay property tax, who does anything about it. We don't. So running the country is not about symbolism. It's not about gestures. It's not about form. It's about putting in place and implementing the things that you've put in place, to help move the country forward. The issue about emolument is actually that the Black's Law Dictionary defines emolument entirely as that which is received as a compensation for services. Okay? Advantage, gain, public or private. And I think elsewhere, for instance, when you become a president, even if you have shares in all these things, there's a trust that is created, and it has absolutely nothing to do with you. You get it? So when people say that, well, it is just book that he wrote, and if you wrote a book as a vice president, even this year, you can still benefit from the book. You know, if really he has properties, the properties will be earning him money. Okay? But what is really the law on that? You know, can he be allowed to make money from these things, from businesses, which may not in a narrow form? The Indian jurisprudence has dealt with this office for profit, you know, deeply, because it's an issue for them. And they've defined it to go beyond holding actual office.
Is there a law? Is there any legal
interpretation of
that prevents him?
Yes, I have to be honest with you. I'm not so sure that we've delved into it as deeply as we need to. But perhaps this is the time to do that. You know, because if you define it narrowly, as it was meant traditionally, because traditionally it was meant to be that if you are maybe executive, you can't do this. If you are, you know, that sort of, to make sure that you can be maybe a minister and at the same time a public servant. That's how it was meant to be defined. Right. But now, considering that you can own 50% of a company by shares alone, and not have any role to play, but you are making money from it, and decisions taken by that company will benefit you. Okay? Or decisions taken by the state may benefit the company. You know, so I think to me it invites us, it invites the nation to look into this and see what are the limits, okay, that a president can do. Because president may not necessarily be a director of a company. Of course he's stopped from doing that. But what stops him, if he has shares in that company, from making money from that company? And what if, as we saw in Maslock, what did the lady do with Maslock, allegedly?
No, that's under investigation.
I said allegedly. Yeah. You know, I was being careful.
Don't go there at all.
Why wouldn't I go there? It's in the public domain. I can't say allegedly.
You can't.
But
I can't.
You can't.
My brother.
Well, he said allegedly.
My brother.
That's fair. Once he says allegedly, it means he's not making it a
That
certainty.
is why we've been so...
Gabi, go on.
Yes, let me go on. You know, so if really there's a company that the president has shares in it, and there's something the company has access to Maslock or that sort of thing, and you know, so it raises all sort of issues that we need to look at.
Yeah.
But at the end of the day, to me, it's not about the symbolism. If he was supposed to pay and he's paid, it's fine. But what about the things that the Constitution demands of him? Has he declared his assets? Did he declare his assets after he left office?
That was a requirement.
It was a requirement, I'm saying. To me, those are the things that matter. You can't, you know, sort of, you know, double in symbolism
And the integrity
and then ignore your constitutional duty. You know, so to me that's an issue, and we haven't had any response from the president as far as I'm concerned.
Okay, you
Not
haven't
officially.
spoken about this matter yet.
Yes.
So
Not officially, but
let's take the very final point from
that he hasn't declared his assets.
This wouldn't have been an issue in some jurisdictions. But just because
If he didn't
some
put it on camera.
jurisdictions where the president already paid taxes anyway.
yes. So this wouldn't have been an issue at all. But we live in a country where the culture to pay tax is absent. People simply hate paying tax. And
Every
indeed-
country,
And indeed,
you just have to apply the law.
and
that's
indeed,
all.
even in colonial times, some of the rows we have witnessed is as a result of tax that the colonial masters want to impose. The pool tax, the Abba rows in Nigeria. So tax
I was in
payment-
England when
payment of
Margaret
tax-
Thatcher's poll tax happened.
Payment of tax is not something that... And so, if you have a president who goes to file his tax returns, and Gabi says to say it's not the symbolism is not enough, that for me is a good example. And if following that, we have one additional person looking up to the president and say, I'll go and pay my tax, it is one person more. And so I think that we shouldn't be little.
But that's not the panacea for the
No,
tax
I'm
challenges.
yes,
you know that.
yes,
You
but
must go beyond
It
that.
must go beyond that, but to also say the president, what he has done is symbolic and it has no effect.
But the president said so. He said this is a symbolic gesture.
Yes, but Gabi is saying it has no effect. That's where I'm coming from.
That's what Gabi said.
He said it's not enough.
It's
That's
not.
it.
No. He said it's not effective, and that we shouldn't rely on these things. I say we should rely on them and then go further.
And go to sleep.
Yes. But Gabi, you can't bait me. I will not allow you to bait me. I will not.
You baiting yourself,
yes.
not me.
So you see,
I've no
for
interest in
me,
baiting you.
the president has shown the way forward. I think that what we should be talking about is how do we, as it were, use that symbolic nature that he's gone through to improve on our tax regime. And if we do that, I don't think that we need to be the office of president thing you talked about.
Office of Profit.
Office of Profit.
Yeah. I'm actually trying to get Ali Nashia on the phone.
I heard
so
somewhere
that
there's a Supreme Court ruling
that
on
to
it.
us.
Yes. Somewhere I heard that the Supreme Court made some ruling on it. But basically, it has to do with an office in which, in the normal course of your business, you occupy. You see? So if you get up in the morning, you wash your face, you take your bath, and you head towards there, and that's where you make your profit. That is an office of profit.
The law says directly or indirectly,
yes,
isn't it?
Yes. So indirectly, if you are doing that. And so, for instance, I have a car. If I remove a part of my car and sell and make profit out of it, you can't describe me as a parts dealer in Abosokai. And that will not amount to an office of profit. But it's an office of profit for the Abosokai person.
If you do it more than 3 times?
That's what I'm saying. It's a regular, normal course of business. That's the definition I gave you. So, this one time selling of the book cannot, in any circumstance, amount to the president breaching any of the rules. And
the book will be sold for a long time.
And this is post-vice presidency.
Yes.
Post-vice presidency.
That's what we are looking at.
Yeah.
You see? So, for me, you need to understand that also as a vice president, he only became president in June last year, late June last year. And so he would have had July. So clearly, before July, he would have engaged in term transactions. And he was filing his tax return for 2012. And 2012, most part of 2012, he was a vice president. The rules don't cover the vice president. And so there's no need to make a fuss out of this. Just look at the fact that as a president, he has fulfilled his obligation.
What about assets declaration?
There's disclosure of the contents.
The disclosure...
It's not an obligation, but it will help.
You see,
it's more of a political decision.
Yeah, and I think he should. I would advise that he does.
But it's a
taking cameras there was a
public, because we have to bear in mind that
and you can find out from
but you can even bear in mind that limitation even applies when the president leaves office.
Yeah,
you get me?
I know.
But that one, that you need approval of Parliament.
Yeah,
you get
I
me?
know.
So it's a law which really has a certain intent, and that intent will have to come into.
I'm just making a suggestion.
I'll read this text message from Silas Samuel Amo. He writes from Kenya. He says, I read an article by PC Apiofori yesterday, and it prompted me to read Article 68(1)(a) of the Constitution, which says that the president shall not, while he continues in office as president, hold any office of profit or emolument, whether directly or indirectly. What then was the income or profit the president filed taxes on? What is it? I am asking this question because Article 68(5) also says that the salaries, allowances, facilities, pensions, and gratuity referred to in clauses 3 and 4 shall be exempt from tax. Would the president have violated Article 68(1) if he filed taxes on profit gained from other business ventures? Of course, we have dealt with this subject for you, and a lot more people have been raising that particular issue. I hope that it's been properly addressed for you. Now, just one more or two more messages on the Supreme Court matter, because there are just too many of the messages on that, and then we'll take just a minute to finish with labor agitations and the suggestions that may be giving.
And all the text messages are on the Supreme Court.
John Bosco says that with the case at the Supreme Court, I think Gabi Asare Dako should have been taken seriously rather than being lambasted a couple of weeks ago. It's very true. The parties are ready, and says other things. And this one from Charles Boating, he says, Massa, you people must talk about how people are suffering to get work in Ghana, and talk about how people are suffering in villages, and stop bringing this stomach politicians debates about all of these things. Thank you for your messages. And I wanted to take just, a minute from each one of you. How do we tackle the season of agitations, labor agitations? What are your suggestions, Abdul Malik?
Well, we have a legal regime relative to industrial disputes. We have institutions of state that we have put in place to deal with the matter. Then, of course, we have the unions, the leaders who lead their rank and file.
Chairman of the Labour Commission says that there's a professor, a doctor, who told him that I understand the labour law, I understand the law, but I won't respect it.
Maybe there's an element of mistrust somewhere. There's been an element of breach of faith somewhere along the line. So it's a combination of the human element and the kind of mechanisms we put in place. I think that's the problem. You see, I've been listening. Somebody said about 18 months, even on issues that had been agreed on by the Labour Commission, even an issue that the court had settled. How come no closure on those things? So we must be looking at people who have been given the responsibility to lead the negotiations or the processes. I think some of the problem comes from there.
I see.
Yeah, it's unfortunate we don't have much time.
Yeah.
I think the problem has to do with all the stakeholders. You know, if you have a dispute and you are standing on, you have an entrenched position and you don't want to shift the goalpost and you don't want to meet halfway, then clearly some of these things will happen. I also think that there's a need for the Fair Wages Commission to be proactive on some of the demands by labor. I also know that some labor unions, leadership particularly, are too militant. It's like to say that that is the way to measure your success. We need to also understand that the cake is not available for all of us. So for me, yes.
That's what is difficult for them to understand.
So for me, there should be a truce for now. With a single spine, it's a new system, and so clearly there will be some teething problems. As we go along, these things will become the thing of the past.
I see. Thank you.
Oh, yeah. As you said, I mean, these are the post-migration issues arising. They are really not new in the industrial relations setup, and we should expect this kind of things happening. But I think that the answer lies in we just obeying the law.
Gabi.
Yeah. To me, the issue is how our finances, our monies are being managed. The bottom line. As I speak to you, over 3 billion Ghana cedis of those overspending that happened last year. We haven't had any persuasive, if you like, reasons as to how the monies were spent. And you know, we are going to have agitations. Why? Because there's no money in the system. And our monies are not being looked after properly.
I see.
You know, so to me, that really is the
solution.
The solution is that, first of all, the solution is that we must have a leadership that can be trusted and can be put to task in terms of making sure that our monies are spent well.
Thank you very much,
The inflated cost of contracts, money is being used,
is the
jobs are not being created.
Is the executive director of the Dankwa Institute. He's with the New Patriotic Party. And Thompson is a lawyer. Abraham Amaliba is a lawyer with the NDC. And Kweku Bako Jr. Abdul Malik is managing news editor of the New Crusading Guide newspaper. I am Samson Ladi Anyenini.
That is title right.
Editor-in-Chief. Okay. Editor-in-Chief.
Thank you.
Okay. I am Samson Ladi Ayenini. I'm your humble host, and this show was produced by the leader under the leadership of Sedem Ofori and supported by John Apia and Kofi Ansa. It was directed by Yaya right here at the Multi-TV studios. I am Samson Ladi Ayenini. The show was brought to you by the kind sponsorship of MTN, Everywhere You Go, and Star Assurance, your solid partner. They've got great insurance policies for you. Go and get them anywhere. There are branches all over the country. Good afternoon. The news is up next.